All right, the final slide of this semester. Now, I got this question a lot, and you will get this question a lot when you become a lawyer from your client. A lot of CEOs don't know how to read the contract. They hold on to what they can read. Now, the meaning of all these provisions that we learned this semester, they have no idea, but they know how to read the name of the country. So for instance, if the governing law says, oh, this contract shall be governed by the US law, they have this instinctive feeling that they are being shortchanged. They are being put into a disadvantageous situation. Okay. So some CEOs will tell you, okay, we will make concessions, we'll compromise on a lot of other things, but please do make sure that this contract is governed by Korean law, believing that that is good for Korean clients. That is good for Korean parties. Okay? That's not true. All right? Contract law, I mean, when you learn contract law in this law school, contract law is transparent, neutral to the nationality of the parties. Right? I mean, when you learn contract law, you never learn the rule that if the party is American, it will get discriminated, right? So it's not the law that, it's not the nationality of the law that matters. It is the role that your party or your client is playing under the contract. Because some laws, not contract law, but other laws, are favorable or more favorable to one party than other laws. For instance, when it comes to intellectual property law, the American law is more favorable to the plaintiff in infringement actions, in lawsuits for infringement. American law is more favorable to the plaintiffs than Korean law is, for instance. When there is a personal injury action, like automobile accident, Korean law, American law is also favorable, more favorable to plaintiffs in those actions than Korean law is. Okay, so if you are negotiating a contract, and if you know that certain governing law, okay, if you know that making certain law, the governing law, is more favorable for your client, then you should go for it. Okay? But it's not the nationality that matters. Putting Korean client under Korean law is not necessarily good for the Korean client. Okay? All right, so that's one myth out of the way. Now, when it comes to forum, okay, governing law is under what law the contract will be interpreted. Now, forum is in which court you will fight it out when there is a dispute. Okay. Which judiciary, country of which judiciary will interpret the contract, right? That's the question. Now, there, you have to think about not just winning in the first place, okay, but also enforcing the winning judgment after winning, right? Let's say you want to make forum Court of Korea, okay? So you want to give the authority, you want to give the interpreting authority to the Korean court, right? Let's say you win in a Korean court of law. You get a judgment from Korean court. But what if the other party is in the US and has assets only in the US and is not willing to pay up the judgment? The judgment is $4 million, but the party in the US says, okay, we're not going to pay. What can you do? The only thing you can do is take the judgment, go to a US court of law that has a power to enforce judgment on the defendant's assets, and then file another lawsuit. Okay? Now, if you believe that courts around the world are friends to one another, you are mistaken. Okay? The fact that a Korean court has signed the paper, a Korean judge signed the paper that says American company has to pay $1 million, doesn't mean that US court has a duty to respect that. There is no international treaty, there is no international law that requires courts to recognize and enforce foreign countries' judgments. Actually, I'm wrong. There is such a treaty, but who has joined? Almost no significant country has joined. The US has not joined, Korea has not joined. Just name any country that you think is a major market. They have not joined. Okay? Only like very small countries that's not a major market, they have joined. Okay? This means that putting the forum for dispute resolution in your home country is not necessarily good for you. Because if you do that, you will have to win at home and then go over to the country of the defendant and win again. Right? I mean, I don't want to be too pessimistic about it. Yes, there is no international law that requires countries courts to recognize and enforce other countries' judgments, but there is a domestic law that does require them to recognize and enforce foreign judgments, but it has these exceptions, right? For instance, if it's against the public policy of the US, then it will not be enforced. Now, Korean civil procedure law, 민사소송법 300 몇 조인데, 나 기억이 안 나는데, has the same provision. The foreign judgment will be enforced, but only to the extent that it does not violate 공서양속. Okay? So good tradition of this country. I mean, yes, the standard does not sound very hard to satisfy, but the problem is you will have to hire a whole another set of lawyers to enforce the judgment. So you are paying the lawyers twice. Not the same lawyers, but you are paying twice. You don't want to do that. Okay? So sometimes if you make the forum for dispute resolution the away ground, right, the defendant's home, right, then you can have one law firm win the lawsuit and enforce the judgment on the other side. What's even better, if the defendant loses at home, they're not going to refuse to pay up. They will pay up immediately, right? Because otherwise, you know, they are fighting a losing battle. Okay. Now, so is it always good to do an away game as opposed to home game? No. If you do an away game, it will cost you more because you'll have to find the lawyers that you don't know. You cannot get discounts. And you may have less chance of winning just because you are in a country where judges and the defendant are of the same nationality, right? So there is that trade-off. There is that give and take when you choose the forum for dispute resolution. What do? Well, you at least have to let your client know that doing a home game has disadvantages. Okay? Doing a home game is not necessarily good for your client. So, what do? Well, I recommend it to many of my former clients that you put in an arbitration clause. As to an arbitration clause, or as to arbitration, there is international law. There is international treaty that requires all the countries of major markets to enforce and recognize foreign arbitration awards. The US has joined it, Japan has joined it, Korea has. Just name any country that's a major, that you think is a major market. They have all joined this New York Convention for enforcement and recognition of a foreign arbitration awards. Okay. So there is no so the cost of filing the second lawsuit is significantly reduced. The second lawsuit in the defendant's home for enforcement purposes is significantly reduced. When you win an arbitration in any part of the world, you are almost guaranteed that you will get satisfaction of the judgment. You will get paid whatever the amount the judgment says or the award says. Okay. So I recommend a lot arbitration. Now, okay, why is arbitration so well recognized overseas and around the world when court judgment is not? Why is arbitration judgment, or we call arbitration award, why is arbitration award considered or given more prestige than court judgments? Why is that? Well, because for arbitration there is extra formal requirement. 그러니까 형식적인 요건이 따로 있어요. 그런 경우에만 arbitration 할 수 있게 해놨기 때문에 그래서 arbitration 판정에 대해서는 더 국제 집행력을 인정해 주는 거예요. is the formal requirement? Well, it has to be clear. It has to be clear and unambiguous that the parties entered into arbitration. Now, court judgments, you can be put into a court even without a clause in the contract, right? Let's say there is no clause giving any one country a forum, right? Even if there is no forum clause, parties will be pulled into courts of different countries against their will. But when it comes to arbitration, they'll be pulled into arbitration proceeding that they only agree to. Okay? That's the law of arbitration. That's the domestic law and international law of arbitration. That arbitration will proceed only if there is a clear and unambiguous agreement to arbitrate. Okay. That's why whether there is an arbitration clause or not is a really important matter for interpretation. Okay. Then what are the conditions that have to be met for arbitration clause to be considered clear and unambiguous? Two things. One, place of arbitration. Okay. And the identity of the arbitrating body. These two have to be clear. Now, place of arbitration. If it says India, that's not considered clear. If it says Delhi, India, then it's considered clear. If it says Korea, not clear. Seoul, Korea, yes, clear. Why? Because if you change the city, the cost changes a lot. Okay. So it has to be specifically, I mean, the idea is this. If the arbitrating body and the place of arbitration is not set, the parties may not come to an agreement on those two things, which means they may not be able to do arbitration at all. If the parties agree on just, okay, we will do arbitration, right? Then the parties will fight over who will do the arbitration where. And parties will want to go with the arbitration body that will be favorable to them, and they will want to do arbitration at a favorable site for them. So only when those two things are clear, arbitration clause is considered valid. The place of arbitration and the arbitrating body. So here is one example. One arbitrating body is International Chamber of Commerce. International Chamber of Commerce. Okay, I mean, the arbitration clause can be really simple. If it just says arbitration, ... International Chamber of Commerce, Seoul, that's a valid arbitration clause. You don't even need a sentence. Okay? But this is a problem. International Chamber of Commerce. There are many organizations called International Chamber of Commerce. There is a Jeju International Chamber of Commerce. There is Seoul International Chamber of Commerce. There is Boston International Chamber of Commerce. So if you want to do the arbitration with the International Chamber of Commerce, then you have to identify further by saying something like International Chamber of Commerce headquartered in Paris. Okay. This is a real case. There was a time that the contract says Shanghai Arbitration Commission. Okay, Shanghai Arbitration Commission. But there is no such thing as Shanghai Arbitration Commission. Okay. There is Hong Kong International Arbitration Commission, and there is a Shanghai Arbitration Center. Okay, Center Commission, not the same. Okay. Oh, I'm sorry. The other way around. Said Hong Kong Arbitration Center. And there is no such thing as Shanghai Arbitration Center. There is a Hong Kong International Arbitration Center, and there is a Shanghai Arbitration Commission. I mean, the place was Shanghai. In Shanghai, there were only two arbitration bodies, Hong Kong International Arbitration Commission, International Arbitration Center, and Shanghai Arbitration Commission. This phrase could mean either of the two. Okay. What will happen? The defendants usually don't want to be sued, right? The defendant will say, if the plaintiff says, okay, let's arbitrate in Shanghai Arbitration Commission, then defendant will say, hey, it said center, probably didn't mean Shanghai Arbitration Commission, let's do it over here. And then they'll fight over who will arbitrate, and they'll never come to an agreement. So in order to avoid that kind of situation, judges around the world made a rule that if arbitrating body is not clearly stated, then it's not a valid arbitration clause. Okay. All right. Finally, arbitration is also good for a couple of other things. Number one, you can choose the venue to be a third country. Each country's the court's jurisdiction, court's power. Okay, 재판권이죠. Court's jurisdiction is determined by each country's law. Okay. Now, let's say there is a contract between American company and Korean company. If they decide to put down, say, Sydney, Australia, as the site of dispute resolution, Australian law may say that, okay, Australian court has no jurisdiction over disputes concerning a contract between American company and Korean company. Okay. So it is dangerous to put a third country as the venue. Why do you want to do it in third country? Well, to make it fair, right? I mean, if your client wants to do it in Korea, if the other client wants to do it in the US, you know, they'll have to compromise at some point, right? So do it in UK, do it in Singapore. Okay. If you do that for arbitration, it's all valid. But if you do it for court, the country that you chose as the venue, the forum, may not have authorized the courts in that country to try your disputes, okay? To litigate your disputes. But for arbitration, you can travel all over the world. So, I mean, I did, when I was a lawyer, when I had the choice to put the third place, a lot of times I put Hawaii as the forum, in the hope that when there is a lawsuit, I can visit Hawaii. And also it was a midpoint between, you know, the continental US and Korea. Okay. And sometimes even if there is an agreement between Korean company and Japanese company, I'll put Hawaii as the venue, right? Of course, I did the contract work too well that there was no dispute. I should have, you know, made some loopholes so that there will be dispute, but then that's against lawyer's ethics. Shouldn't do that. But putting down Hawaii as the venue, yes, you can do that. You can, because, you know, I told you strength and weakness of making the forum home game or away game. And after your clients have considered all that, if your client still wants to do it in Korea, and the other side wants to do at their home, then you have to compromise somewhere, and it's usually third world country. Usually third country is your best option. Or sometimes sometimes the foreign company may want to do it in Korea, right? For the reason that, you know, they don't want to file the second lawsuit for enforcement purposes, right? And your client may want to do their home, right? So there has to be some compromise. So for arbitration, you can do the compromise. And another good thing about arbitration is that there is no appeal. So one-shot deal. Now, because it's a one-shot deal, some law firms charge more, even though they do less work. I don't like that. If there are enough law firms, if there are more law firms that are competing with one another, I think the law firms will stop doing that, because the law firms do much less work for arbitration than for a lawsuit. Not just because there is no appeal, but because procedurally it's much safer. I mean, it's much cheaper. For instance, you can file your briefs through email just by attaching a PDF. Okay. If you file something in Korean Court of Law, you have to, you have to make seal imprints, right? 물론 이제 요즘 전자소장 때문에 좀 더 편해지긴 했죠. And also you can do your hearings over the phone. Right? So, I mean, in court, you have to travel there. You have to travel to the court. You have to appear in person. You don't have to do that in arbitration. Okay. So for those reasons, it's a lot more. It's a lot more efficient and cost-effective for your client to do arbitration if the law firms don't overcharge your client. Okay. And also there is a benefit of secrecy. Arbitration awards are not published. Court judgments are published. Okay. Now court proceedings will disclose a lot of details about your business, your client's business. Okay. So that's another benefit of arbitration. Okay. Any question, comment on this slide? Any question or comment for today? Yes.
When you said about the mini NDA, this mini NDA, although it's part of a LOI, the mini NDA itself is binding.
Yes, binding. So, LOI and MOU are, yes, binding, but to the extent that it says binding, right? So exclusivity is binding, the non-disclosure is binding, and also duty to negotiate is also binding, but only, but the attachment X, right? All the substantive provisions that they are supposed to negotiate toward, that's not binding. But that's where all the good stuff is, right? That's where all the juice is, right? That's why we are just casually calling LOI non-binding, but technically it is binding. Right? So it's got to have, good point, it's got to have dispute resolution clause. It has to have a governing law clause. So all LOIs, all good LOIs and MOUs have all the boilerplates. Okay. The last two slides I went through, the boilerplates. All LOIs should have that because it is binding to some extent. I mean, if it's not binding at all, there is no point in entering into the document, right? It is non-binding with respect to the objectives of the contract, right? 그러니까 계약의 목표가 되는 그 실체적인 조항들이 기속력이 없다는 거지. 그 협상을 진행하기 위한 이런 절차적인 조항들, 비밀 유지 또는 독점 협상권 이런 것들은 당연히 의미가 있죠. 기속력이 있죠. 없으면 체결할 필요가 없겠죠. Okay. Again, the boilerplates, you should refer to the sample agreements before, and you can match. Okay? You will find most of them in your license agreement. You'll find them in your distribution agreement. You'll find them in your, sorry, I didn't give you service agreement. I will give you sample service agreement anyway, and I'll give you sample LOI as well. We only got 3 students. Learning is more important than test, so I'll give you all of that. Okay, any other question, comment for today? Any other question or comment for this semester? All right, that's the end of the semester. You did a good job and hope it helps you when you become a lawyer so much that you do end up thanking me far away. All right. That's it.